sir.
Your Honors. May it please the Court. My name is Alec Hayes, and I appear on behalf of the appellant, Nationstar Mortgage, LLC, in this case. The issue on this appeal is whether an involuntary dismissal...
5 minutes for rebuttal.
3 would be great.
Okay, you got it.
Thank you very much. The issue on this appeal is whether an involuntary penalty dismissal resulting from repeated discovery sanctions can serve as the basis for a trial court denying a mortgagee's right to foreclose based on collateral estoppel. The parties seem to agree overall with respect to the elements of collateral estoppel, but disagree with the application of those elements to the facts in this case.
Mr. Hayes,
Yes.
help me understand what the trial court did with the payments allegedly missed from February 1st, 2015 and after. I'll lay out what my concern is. You know, you stepped into the shoes of the predecessors in interest.
Correct, John.
And so you could not have any greater rights than they had.
Correct.
They were foreclosed from pursuing foreclosure based on defaults from January 1st, 2013 and January 8th, 2015.
Correct, Your Honor.
Basically, by dismissing that with prejudice for the mediation violations, the court said you cannot rely on the defaults during that period.
Right, Your Honor.
So because they could not do that, you stepped into their shoes. So whatever you want to call it, I frankly, I'll just lay it out there, have no problem with you all being foreclosed from basing your action on defaults during that period. I don't understand at all, however, because you basically, each month of non-payment is a new default. So I don't understand why, even given how the second complaint was drafted, it did allege defaults outside of the forbidden period. So, and I don't understand the trial court's order of how it said, well, you can't base a foreclosure on those defaults either.
Right. So, Your Honor, the case law, and this kind of goes into the unique nature of a mortgage obligation, which has both roots in law and in equity. And the nature of a mortgage contract is a continuing obligation. And as you pointed out, that there are multiple payments and there are multiple opportunities within to default. So the case law has shown that when a party asserts a separate and distinct cause of action, which is the separate and distinct dates of default, which is the month after the default, then that creates the opportunity to pursue those specific defaulted payments. And that kind of...
Talking about the period, period prior to 2013?
Right, Your Honor. So the dates of default are separate. We have the first date of default is January 1st, 2013, and in the second foreclosure action, it's February 1st, 2013. So the date of default was changed in the second foreclosure action in order to be able to recover the payments continuing from February 1st, 2013 and continuing forward.
So does the rule apply to prevent you recovering payments that the judge said he was specifically precluded from recovering from February of 2013 to January 2015?
No, Your Honor. With respect to the separate dates of default, there's case law that says that even, and this is Ferrero and Provident Funding adopting, even if my client was able to allege the exact same dates of default and any and all subsequent payments, then the meaning of that phrase, the meaning of the date of default and all subsequent payments is expanded to include the continuing missed payments that have occurred between the first date of default, the end of the first action, and the second date of default that is alleged in the second action. So,
And that's why I asked you about those defaults that were charged that did not fit within that period. But Provident Funding still left open the possibility that the indebtedness from that period would not be assessed, might not be assessed against the defendants, right? So maybe the trial court should not have dismissed the complaint because it alleged a continuing default outside of the period asserted in the first complaint. But has your position all along is that you should still be able to recover the amount of money lost by those defaults during that period? And so you've got this all or nothing position?
that's not our position, Your Honor, and I apologize if I misspoke. If there is a situation where this case is, if this appeal is affirmed, and we separately go after, then the appellant separately attempts to foreclose on a separate date of default, that's what the law says that my client would be able to do. That is what the law says that appellant would be able to do, is being able to allege a separate date of default and instill a new foreclosure action. So the all or nothing component of it is not what we're arguing. But this case is about collateral estoppel, and the summary judgment order, the final judgment that the trial court entered in the second foreclosure action, was based on collateral estoppel, which we argue in our briefs and argue today is an improper ruling because collateral estoppel does not apply to these facts.
So it seems to me like you're saying two different things. And actually, I apologize, Judge Valenti, because I was trying to elaborate on your question, and I feel like I've hijacked the whole discussion.
I'm fine. I'm very happy to get along. You said the appeal of a dismissal is appeal from a summary judgment.
Correct. It's an appeal from a summary judgment. Correct.
But, so are you saying that you should be able to recover based on that period that was addressed in the first foreclosure?
In this case, Your Honor, yes. And that's
Simply because you bumped the first date of default to February?
That's correct, Your Honor. And
So
that's
that is an all or nothing proposition. You're not saying that you could charge this longer period, but this part may be excluded and you recognize that. You're saying you can charge this longer period, and just so long as you bump that date 1 month,
well,
you get the whole enchilada.
right. And that's what Ferrero says. So in this specific case, I guess as you would put it, it's an all or nothing. But what I'm alternatively also saying is that if this case if this appeal is affirmed, if the judgment of the trial court is affirmed, and there is a subsequent foreclosure action, that is permitted under the letter of the law.
Well, doesn't it depend on what the subsequent foreclosure action alleges?
Your Honor, it would be based on a separate date of default. So if we have a statute of limitations for 5 years, and let's say the appeal was affirmed, and NationStar came in and alleged a date of default that was within the statute of limitations, so let's say August 1st of 2019, that would be permitted under the letter of the law because there would be an opportunity to collect on those defaulted payments because of the continuing nature of this obligation. And that's what we're arguing. I'm not sure if I perfectly understand the all or nothing component of your question, but it's...
Well, what I mean by it is, in the first foreclosure action, the trial court said to your predecessor in interest, you cannot pursue default, or you cannot pursue foreclosure based on defaults occurring between January 1st, 2013 and whatever, January 8th, 2015. You can't pursue foreclosure based on defaults during that period. You then come in and you're saying, well, we're a successor in interest. We recognize that this is both a legal and an equitable proceeding, but we're stepping into the shoes of these first guys, and we're going to pursue foreclosure based on defaults within the period that you said the first guy couldn't pursue. Because we're a whole new guy, and you can't hold that against us.
Well, the successor in interest component of it is not pertinent to this, because the successor in interest would step into the shoes of the original foreclosing party.
Mm-hmm.
When the final judgment is rendered in the first foreclosure action, that effectively closes the continuing obligations of the mortgage. So if your question is whether or not, once that final judgment is set down, can we then collect on the amounts that are owed between the first alleged default date and the final judgment, then the answer is no. But if there isn't a final judgment and there isn't a closure, if you will, with respect to the continuing mortgage payments, then those payments are collectible and those defaults are actionable. So,
Under 1.420, wasn't that involuntary dismissal and adjudication on the merits?
the adjudication on the merits, and that's our second, and that's the main argument with respect to the collateral estoppel being inapplicable here, is that the adjudication was never on the merits. I understand the with prejudice.
Well, it doesn't matter, does it? The rule doesn't, the rule says it is an adjudication on the merits, whether it was or wasn't is irrelevant.
But the courts disagree, Your Honor, and and there are.
Well, if you voluntarily dismiss your foreclosure 2 times, that's not an adjudication on the merits either, but you are barred from foreclosure based on those alleged defaults, right?
Correct.
And even if you come in later and say, well, it was the last guy who dismissed it, not us, so you shouldn't hold those 2 against us?
Right, Your Honor.
How do you distinguish those?
So we distinguish that by, and there's not a ton of case law on point with respect to what it means to be, for a matter to be fully litigated. So there's a confusion that is in both the trial court's order as well as Appellee's brief that confuses the aspects of claim issue preclusion, collateral estoppel, and res judicata. Res judicata does not matter whether or not the ruling was adjudicated. Whether the res judicata focuses on whether there was an opportunity. It doesn't matter whether or not the matter was fully litigated.
Well, you had the opportunity, or your predecessor in interest had the opportunity.
Correct, but that's not collateral estoppel, Your Honor. That's res judicata. The opportunity doesn't matter. It's the actual fully litigation, and that's the fully or actually litigated. It's interchangeable in various cases. So collateral estoppel requires the issue to be actually and fully litigated, and it must be essential to the adjudication. When you have, in our briefs, we argue that this situation, because there isn't a ton of authority on it, this situation resembles a default judgment, because a default judgment is a procedural dismissal. This was also a procedural dismissal. So the fact that there was and we can argue about whether there was an opportunity to litigate it, which is a res judicata argument, it is not a collateral estoppel argument. So
So you're saying that the footnote Provident Funding is completely inopposite?
The footnote,
It doesn't address the question.
Provident Funding doesn't specifically state that they don't address the question. And that's, and the reliance on that in the trial court order, I think, is misplaced. I think the judge also made the same mistake with respect to conflating collateral estoppel with res judicata.
Well, how do equitable principles fit into this then? Because there, as you've acknowledged, there is an equitable component to foreclosure. And if the court has dismissed the first complaint because of the misconduct of the mortgagor,
Mortgagee.
mortgagee,
Yes.
because of the misconduct of the mortgagee, Doesn't that have to have some teeth? I mean, doesn't that have to have some meaning if this is an equitable proceeding? Because otherwise, for some to just come in later and say, this is a whole different proceeding because we're now alleging a different default date, even though that happened to fit within the period that we're supposedly not allowed to collect on.
So the equity principles is what a lot of courts examining these issues have focused on. A lot of courts focusing on any mortgage issue focuses on, because there's an action in law based on the contract, based on the promissory note, and then there's an action in equity with respect to the mortgage. So there is, and it bears it goes without saying that the first dismissal in the 2013 foreclosure, that sanction, that dismissal with prejudice was after the first discovery violation. That was not after the second discovery violation. There are 4 here, and I'm not going to stand here and argue that my client or its attorneys or its predecessors acted in any proper form whatsoever. But that's not what this case is about. The case is about whether or not the separate action there can be a judgment entered in favor of a mortgagor based on collateral estoppel grounds, because collateral estoppel, which was referenced as the very first paragraph in the trial court's order, is not applicable here, because we don't have an adjudication on the merits that a matter was actually litigated in this matter. And again, it goes into a confusion with res judicata versus the collateral estoppel. The equity principle of this is, and again, I'm not making it in any light of the trial court's ability to sanction a party for disobeying the Florida Rules of Civil Procedure or any trial court order or anything like that. But there also has to be some equity on a party that has been in breach of contract and hasn't made a payment on their mortgage in over a decade. And there has to be some give and take there with respect to what is expected of a party that is simply not performing on a contract for over a decade.
And that is absolutely true, which brought me back to my original question is, help me understand why the trial court in its summary judgment order said you also can't foreclose based on defaults from February 2015 and after, because the second complaint clearly also alleges those. And that would be the balance. You can't go after them for this period, but they're still not paying. So go after them for that period. The trial court seemed to be under the impression that you had to actually amend your complaint to only allege this limited period. But I think what Ferrero and Provident Funding would support the proposition that it doesn't matter how you allege it, because you've got these continuing defaults, but you can't necessarily recover for the defaults that overlapped with the first foreclosure. That's what I don't understand. Why did this not proceed? And it would just be, well, we don't count these, but we proceed on these.
Right, Your Honor.
But your position is that shouldn't have been what happened anyway. My position is that the trial court shouldn't have made that ruling in that way. The trial court has, and this shows in the transcript as well as the order, the trial court seems to rely on the footnote in Provident Funding and not on the letter of the law of the entire universe of the other cases that are involved on this specific issue. That he takes what we identify in our briefs as the minority view with respect to collateral estoppel, which is the opportunity to litigate, not the actual litigation and the actual adjudication on the merits of the complaint. So the notion that the trial court was attempting to make law rather than interpret what law had already existed, and there's a lot of
to put it softly, there's a lot of waxing poetic with respect to how foreclosure actions should be and focusing on it.
I don't want to interrupt you, but I let you go the full 20, so you want 3 minutes for rebuttal?
Oh, I
If you want to
apologize.
stop now, I'll give you the 3 minutes, because we have to do this question.
Absolutely. And council can have extended time as well based on that. Thank you very much.
We'll see about it. Okay. $64,000 question to be, is the judge wrong in dismissing this case, entering summary judgment because he alleged the same allegations of default on that February 1st date, but he didn't, he said, and all subsequent payments, which would be a matter of precluding the evidence to show he's entitled to recover, but he can get payment after that default date that the judge said he precluded.
The judge is not wrong, Your Honor, and good morning. My name is Scott McKay, and obviously I'm here on behalf of the
I
Browns.
want to get that question out before I forgot.
Certainly, and I appreciate that. The judge was not wrong, and I'll tell you why. There's a couple of reasons. The first of which is, let's remember, this is not the first time this case has been before this honorable court.
No, I know, the first time was dismissal based on the four corner rule.
Correct.
It's not relevant to our case.
It is and it's not. But let's remember that the judge gave them the opportunity previously in this action,
And they declined to amend.
and they declined to amend it. This is the,
But they're saying they're not required to amend.
okay, but they are, because the words of dismissal with prejudice has to mean something. Now, the original trial judge was Judge Nancy Donnellan, who dismissed this case in January of 2015. When she entered the order dismissing it with prejudice, the words with prejudice mean something. There are no other cases that I have seen anywhere in the reporters where we have.
Does that mean only that they're prevented from recovering the allegations of the payments for the allegations of the complaint? Or can they still file because it's foreclosure, all subsequent payments allege the date outside that 2015 date?
And this comes back to the all or nothing concept that Your Honor was bringing up earlier. They've always had this all or nothing idea where they think they can just bump that date a month forward from 2013 and try to base their default. You have to allege in a foreclosure complaint that a payment was missed as of a date certain and all subsequent payments. All that the bank has ever done is bump that date a month further forward, but still within the prohibited period from the original dismissal with prejudice. The trial judge gave them the opportunity in this case to simply move the default date to February of 2015. I advocated at the time that that shouldn't even be allowed, that the case should have been dismissed and the bank should have been required to refile a new foreclosure action, again with a new case number. The trial judge said no. On the original motion to dismiss, which was reversed because he took judicial notice of something, and Your Honor said that shouldn't have been done, but he did give them the opportunity to bump the default date in this case to February of 2015 and move the case forward from there. They didn't want to do that. They actually moved to have their own case dismissed with prejudice because
You're
this.
saying it's not just a failure of proof. It's something they can't legally do.
Correct.
They can't legally say all subsequent payments, they keep following the same thing.
Well, obviously, they always say all subsequent payments, but when this case was dismissed with prejudice in 2015, the judge, that word has to mean something. And I understand.
The position is it means they can't even allege it.
Correct. And Your Honors, you know, I'm aware of the case law on this. This is the exception to provident finding, which Your Honor was part of that court, I know. And Judge Vellante, you know, I've read, and I understand where you're coming from because I've read your dissent in Green Emerald versus 21st Mortgage and your concurrence in Schaefer. So I'm aware of, you know, kind of the ideas that you come with, and I may agree with you on those as well. The other thing that I would agree with, however, is the Justice Solario had a special concurrence in Spencer versus DITAC, another case where we talked about these interesting foreclosure rules that we seem to make in foreclosure cases. A dismissal with prejudice, we know means something in the real world. The better question is, does it mean anything in foreclosure court? Because we seem to have these different steps and rules, and it does mean something in both cases. You can't allege in this case a default that comes between January of 2013 and February of 2015 because that case was dismissed with prejudice, and with prejudice has meaning. The trial judge, in entering that dismissal with prejudice, absolutely did not intend to allow the bank to simply bump the date to February of 2013 and try it again. Because if that's the
That's
case,
within the same time frame. So.
Correct.
The rule precludes that.
correct. The trial judge in this case did specifically state that all they had to do, whether we look at the ruling on the motion to dismiss or we look at the summary judgment ruling, the judge commented that as long as they were alleging something out after February or after January of 2015, after the dismissal with prejudice,
All subsequent payments occur after January 2015?
certainly would be part of that, but they have to allege the default within that period. That's the problem they have. And the trial judge gave them the ability to do that. I still don't understand as I stand here, why did they not take him up on that in the motion to dismiss? He said, just amend your complaint. He gave them time to amend the complaint to a date outside of the prohibited times. Why did the bank aggravate their damages? Why did they aggravate their claim instead of just doing what the judge told them to do? Put your default date as February 2015 in this case and move it forward. He gave them that opportunity and they said no. The bank insisted that their case be dismissed with prejudice to be able to get it here to argue about the judicial noticing concept of it. They were given that opportunity in this case. They said no to it. They have to allege a date of default outside of the prohibited period. This is the footnote 3 of Provident, where this court left open the idea, didn't rule in Provident, but certainly left open the idea that there are or could be preclusive effect on the right case. There are no other cases out there where there is a dismissal with prejudice as a sanction. There's a lot of other case law out there about 2 dismissals and voluntary.
Well, sanctions involve playing around with mediation or something like that.
Correct.
So you're saying there's multiple ways to affirm this, one of which was as a sanction, another one of which is an appropriate dismissal because they didn't amend the complaint as they were given the opportunity to do so. They were required to do that. They want to proceed with a new foreclosure.
That's correct. And they could have done that in this case without suffering the consequence of a dismissal in this case, without suffering the consequence of being found to not be a prevailing party and having attorney's fees against them for that. The court gave them that opportunity in this case number. Just amend your complaint and move it forward. They didn't want to do that. And I don't know why, but it does come back to Your Honor's question. This has always been the all or nothing idea for them. They believe that they can just bump that date of
Well,
default.
obviously, they want to get those payments in that period that the trial court said you lose on that. They still want those payments.
Of course they do, but you can't get them.
Well, now they have statute of limitation problem, all kind of problems, not to mention the rule. But if they file a new foreclosure after this appeal is done, your position is they can only start a new case after that 2015 default date.
I had 2 arguments on that, one of which was never reached.
Well, we didn't get there yet. So.
Sure. I absolutely believe if they're going to file a new foreclosure, it needs to be surely after the January 2015 dismissal. Now, I still take a position that that dismissal with prejudice way back in 2015 precludes them from foreclosing.
So you're saying they lose the mortgage, essentially?
But that's my position. I've not argued that. It wasn't the basis of the trial court's.
No, you didn't ignore my question.
I just want to make sure I'm not ignoring you, sir. I do take that position, but the trial court never ruled on that. That wasn't the basis of the summary judgment ruling. The trial judge's summary judgment ruling came down in collateral estoppel grounds and was eminently correct. It doesn't seem like any of the elements are really contested with regard to collateral estoppel, except for number 2, which is this idea of whether something was actually litigated, fully litigated, or whether there was an opportunity to litigate. When you actually read the case law on the collateral estoppel, that is usually enforced by a plaintiff against a defendant. And the way that test seems to swing is whether it was a run-of-the-mill kind of standard default judgment where we filed a lawsuit, we defaulted you, and there was nothing happened in the lawsuit. The majority view on that seems to be, okay, there's not preclusive effect from that. That's a garden run-of-the-mill default judgment, nothing there. But the remainder of the cases, including way more current, no Florida cases on this subject, but the 11th Circuit spoke on it in the Creech case, which I argued, seems to be that if there's a little more meat on the bone in the litigation, as long as it's litigated, the case has some litigation, it doesn't go out on a default judgment, that there is preclusive effect. And again, remembering that this is usually something that plaintiffs invoke against defendants. Remembering that the case that I cited, the Creech case, was they found that the case was actually litigated after the trial court entered a default judgment mid-litigation based on a discovery sanction. The 11th Circuit said, okay, That's actually litigated. So if actually litigating is defaulting somebody as a discovery sanction, and for some reason, the presentation that I heard from opposing counsel in their brief calls what happened in this case a discovery violation, it wasn't. It was a mediation sanction, not once, but twice in the first.
Let me ask you an obvious question. There was no countervailing affidavit filed alleging a new default date after they got the motion for summary judgment, outside the window that the judge precluded them from seeking damages on.
That is true. That there were no affidavits.
So they were given an opportunity to amend the complaint. They also had an opportunity to file an affidavit, and that was not done. So whatever that interpretation was, the judge said, you can't get any of these damages, and they refused to amend to add a new date.
Correct. Just as your colleague said, this is an all or none mission on their part. I don't know why they made it an all or none mission, but it has always been, we're bumping it 1 month. This is an all or none mission. And this is the only case that you're ever going to see where there was a prior dismissal of a case as a sanction. As I said, there's plenty of dismissals, the 2 dismissal rule, dismissals without prejudice. There's a lot of that out there that has case law that goes all different directions. I haven't seen any cases where they're looking at a preclusive effect based on a dismissal with prejudice as a sanction. Now, opposing counsel throughout their brief used this word penalty quite a bit, and they were talking about penalty sanctions and things. That's not Florida case law that brings that up. As best as I could tell, the idea of the penalty sanction, or penalty dismissal, I'm sorry, was the term they used, seemed to have come from a Randa Coal Company case that they cited in their brief, which was a 1991 Western District of Virginia bankruptcy case where they talked about a penalty dismissal. That's not a Florida law case. Interestingly, in Randa Coal Company, that was a voluntary dismissal under Federal Rule 41A, and that came after, the 2 dismissal rule in federal court. The better case law on this is Creech, which is the 11th Circuit from 2019, where Creech said actually litigated means basically there's just got to be some meat in the litigation.
It doesn't necessarily mean decided on the merits, right?
It does not necessarily mean decided on the merits, correct. And the case law bears that out. You have Creech, I cited In re Bush, I cited In re Daly. It doesn't mean you have to sit down and say, okay, did the borrower miss the March payment for 2013? Did they miss the April payment? You don't have to do that. This idea that it has to be, and there's 2 different tests, actually litigated or fully litigated or somewhat used interchangeably. It doesn't have to be done in that fashion to get the on the merits adjudication. We had it on a dismissal with prejudice is on the merits adjudication in this case. And I didn't.
The failure to make all subsequent payments was alleged in the original complaint that was dismissed with prejudice also.
Yes.
But the court only said you're barred from this 17-month window.
Correct. The court was very clear in its summary judgment order. I think they even said, more concerning are the payments that happened after that. But the court had previously
Doesn't that
given.
relate to acceleration of the whole balance, more than one payment? That you have to allege that to accelerate the balance of the mortgage.
Correct. You have to allege a date of default to accelerate the balance from a certain date forward. And that is why the date matters. That's why the judge gave them every opportunity to say, amend your complaint to February of 2015 and say that date and all payments forward so we know how we calculate the amount of the debt that the borrowers allegedly owe. That chance was given to them. And again, it's hard to envision why they didn't do that. Why did they disobey that order?
So let's go fast forward. You're at the summary judgment and you want to figure out the damages. Doesn't the judge just say, okay, red line out the 17 payments, we calculate the balance because they still defaulted all subsequent payments after that 17-month window?
You're asking if that was an available choice.
Well, that's a failure of proof on their part. I'm asking you, why would the judge be precluded from still entering summary judgment for them and accelerating the balance minus the 17-month window that he said you can't get those damages?
You still have to allege a date of default that's a valid date of default. There's no valid date of default until February of 2015.
And so that's alleged it's within the allegation, right? It's within they do allege a default as of that date. They just allege stuff behind it too.
By using the term all subsequent payments, I think is your question. I suppose so, but we still beg the question. The trial judge gave them every opportunity to simply amend it in this case number to do that. at the motion to dismiss stage 2 years ago. When we talk about this concept of equity and fairness, which Your Honor hit on with opposing counsel in the argument, let's ask ourselves a couple questions. A, 2 years ago, they were given the opportunity to do it, but didn't. Let's remember that after the first foreclosure was dismissed with prejudice, they waited almost 2 years to refile it again. There's all this in their brief, there's this entire concept about, I want to use their quotes to make sure that I get it right. They talked about equity, pernicious results, manifest injustice, unjust enrichment, penalty dismissals, and they referenced the appellee receiving a free home. Those are all the words that they use. But let's talk about equity. Between the first foreclosure and the second, they wait 2 years. They're sanctioned twice in the first case for mediation violations. They're sanctioned twice in this case for mediation violations.
The trial court did not consider that as the basis.
I agree with you, but we're talking about the concept of equity here because Your Honor's asked opposing counsel about equity, and opposing counsel's brief talks all about equity. So I agree that that wasn't referenced, but in the concept, they're going to bring up equity. This is unfair what happened to them. They were sanctioned twice in the first case, sanctioned twice in this case. We're on the heels of getting sanctioned the third time. That hearing was coming up a week after the summary judgment hearing. They waited over 2 years, or around 2 years, from the dismissal of the first case until they filed the second foreclosure. And when they talk about, in the brief, they talked about a free house. But as Your Honors have pointed out, the trial judge in this case expressly said, bump your date of default to February of 2015 and go. Where is that a free house? They literally in their brief put to you that this is a free house for the appellees. It's not.
But what if the trial court under Ferrero and, or Foreo rather, and Provident funding, what if the court was wrong in requiring them to do that as opposed to saying, all right, let's just go. And as Judge Belanti said, but we'll just exclude those, that indebtedness from that period. But we've got your complaint here, we're good to go on that. And
Sure.
what if the trial court had, you keep talking about giving them the opportunity. Well, what if they didn't need the opportunity? What if the complaint under that case law was fine as it stood?
Why did they invite their own heir then? But to answer that question, Nolan, which I cited in my brief, to remedy a lesser evil, Nolan required the dismissal of that suit. I would argue that the trial judge should not, even on the motion to dismiss, have granted them the ability to amend. I argued against that. I don't think they had the right to amend in this case. But the trial judge said no. He quoted the case law from his order, I think was October of 19, if I remember it correctly, quoted the law, the right to amend, and equity and fairness. The Nolan case gave the court the ability at that time to say, no, file a new case.
That's not what happened.
No,
They
but
had the opportunity to amend it,
correct,
and they declined it.
correct.
We're back, it's a chicken and egg argument.
Certainly, but I'm saying that the Nolan decision would have been, had they read Nolan and had the trial judge enforced Nolan, this result would have been far harsher for the bank. So while I understand your question, do I think the trial judge could have simply said, okay, I know what you wrote down, but we're only going to look at the payments February 15 and forward? No, because you still have to allege a date of breach that is valid in a foreclosure complaint. You have to put the hard date down. So I don't think that could have happened. But again, the judge gave them that ability, and they refused the ability. This has always been an all or none argument. They tried to run from that in their initial presentation today, saying, well, it's not really all or none. I don't know what that means. It's always been all or none for them. It's been all or none for them because they didn't amend, and they took their first appeal to get here because they didn't want to amend. They have aggravated their damages. They have created this problem. And that's why
Their argument might be better taken if all subsequent payments was not qualified by the trial judge to say, hey, I change it beyond this date because I am not going to allow these damages here. You already told them that, and they didn't amend. So your argument, I think, has some traction, but I'm not sold on it yet.
I understand, and I agree with you entirely. Had they done what the trial judge said, had they simply bumped that date in their amended complaint in this case, had they moved that to February of 2015 and said, okay, amended complaint, it's February of 2015, and all subsequent payments, they've got a lot better case. They still probably have a breach letter problem. They're going to have a proof problem at some point, but we didn't get to those questions. Surely at that point, I still argue that the dismissal with prejudice means they can't foreclose at all. And in all due candor, I don't know that that argument was going to sell to the trial judge. It's
to make it.
right. It was in the pleadings. I intended to sell that argument. I don't know if that argument was going to get there, candidly. I would rather guess that it wouldn't. But on the ruling that we had, on a collateral estoppel ruling, what the trial judge here is eminently correct and eminently supportable. They didn't amend the complaint date. Nobody knows why. But they don't get to come before this court and throw their hands up and cry equity and cry that the borrowers fouled here. They were sanctioned almost 5 times. They were sanctioned 4 times and were set for a 5th. The trial judge gave them every opportunity, gave them every out to amend their complaint, gave them every out to foreclose this house, and they couldn't do it. It's a foreclosure. It's not that hard. You allege a date of default, allege some standing, allege that you own and hold the note or have the rights under the note, go to trial and put up the proof. This isn't the borrower running them ragged, as they seem to indicate in the brief. The equity is on the side of the borrowers in this case. So for those reasons, I'm happy to answer any questions that your honors have, but a PCA is exactly what this case should have. The trial judge thought out what they were doing.
Is there a motion for fees in this case?
There are.
For your side?
Absolutely. We demanded it at the trial court. We demanded it on.
Sure. All right. You done? Thank you, sir.
Yes, sir. I'm happy to answer any questions, obviously.
I have no questions, Judge.
Thank you.
We're good.
Thank you.
You've had 5 minutes to rebuttal, I think, right?
I asked for 3, or I'll take 5.
No, I'll give you 3. You did it for 3.
I'll make it 5.
The next question, I'll let you finish the last question. Take 2 minutes to finish the last question.
Sure. I'm sorry, Your Honor, I didn't hear you.
What? No, you got 3 minutes. I'll give you more if it turns out you need more.
Sure, I appreciate that. So at the onset, I'm going to agree with counsel that there just simply isn't a ton of authority in this specific issue with respect to.
Why don't you, does the record tell us why you didn't amend the complaint in this case? When the judge said, hey, change the date of the default. Because you allege a date within the same period that the judge says you can't get damages for that, and he's implying you can't even allege that as the basic default. All subsequent payments isn't going to say the date the way the judge interpreted this situation. Is that true or false?
Right, and it's true that that's the way that it happened, but it's fault. But the judge's interpretation of the existing case law was incorrect in our
I know,
opinion.
but if the judge tells you to do something, you just say you're wrong, and you don't do it, you don't appeal it. Where's the logic in that?
Well, I believe and if we're talking about the first foreclosure, it was attempted to be heard for rehearing. The motion for rehearing was filed out of time, so it was never heard, and that's why they had to
And
be.
then who filed the appeal? You filed the appeal? So you waived the motion for rehearing by not arguing it? Is that what you're saying?
Well, the first foreclosure action was not appealed, Your Honor. It was.
I got that.
They moved for rehearing, but it was not. It was never. There was never.
Okay, so that's irrelevant to today. You didn't file for rehearing of this summary judgment?
We did, Your Honor.
You did, and that was denied.
Yes, correct.
Okay, so we're back to where we are.
Right.
Keep going.
So, but with the issue with respect to the dismissal, to the with prejudice designation, and that there is limited case law, there is Espinoza, which is a Southern District of Florida case decided in 2014, was based on the finding of the issue whether initial foreclosure action was dismissed with or without prejudice. That distinction is, quote, irrelevant to its analysis of whether the acceleration of a mortgage note barred subsequent foreclosure actions brought outside the statute of limitations period. So that is in line with Ferrero, which there was the all subsequent payments language, even if the same exact dates of default were alleged, it would still be permitted in the second foreclosure action. So this notion that the trial court and my colleague on the other side relies on with respect to the changing and they only changed it a month out and that sort of thing. All of that analysis is irrelevant because the date of default could have been the exact date of default is in the first foreclosure action, with the exception of the final judgment that came down. So once the final
I'm going to extend you 2 minutes. So you got full 5 now, but that's it, okay?
Okay.
Go ahead.
And just a couple of other points with the opportunity and the court leaving the door open to amend the complaint. That is not what the basis of collateral estoppel. That's our argument, that the basis of collateral estoppel is actual litigation, not the opportunity to litigate the matter. So just because there was an opportunity to amend and there was an opportunity to file the second foreclosure action, that's irrelevant with respect to the issue of collateral estoppel, which is what the summary judgment order is based on entirely. The issues with respect to the number of sanctions and the council's actions or the lender's actions in the lower court, all of that is not relevant to the specific final judgment that was entered on summary judgment. And that has to do with the issue of claim preclusion or issue preclusion, collateral estoppel. The trial court it confused this issue. They confused the issue, and there is a distinction between collateral estoppel and res judicata. That specific line of argument is a res judicata argument because res judicata does not require actual litigation. And in numerous case law, it's actually
So if the judge had said this is barred by res judicata as opposed to collateral estoppel, we would still be here?
well, res judicata also doesn't apply in this because res judicata, the cause of action, the issue with res judicata is not found when you allege a separate date of default. So, and that's Bartram, that's Singleton, those are those cases that say if you allege a separate date of default, res judicata is not applicable to those facts.
Well, Bartram and Singleton, I think both.
I don't want to interrupt you guys, but this is the last question because you're technically totally out of time.
Bartram and Singleton both involved, I think, second complaints where the entire period was outside of the period of the first complaint. I know that's true in Singleton. I think it's true in Bartram. There was no overlap between the two periods at all.
Right. But if we look at those two cases with Ferrero and have the date of default actually doesn't matter because when you have the language of and all subsequent payments, which is expanded as time goes on and a party remains in default, that expansion changes the meaning of what those are. And Your Honor, I'll end my time there, but we would respectfully request that this matter is reversed and remanded to the trial court for further proceedings.
Well, I invite the card to both attorneys, did a great job tonight. Thank you very much. Have a great day.
Thank you, Your Honor.
Thank you, Your Honor.
All rise.